Hello everyone, this is Abhishek Jain and you are watching Law Curators. Continuing our webinar series, today we are going to discuss the topic Public Policy and Enforcement of Foreign Arbitration Awards. To enlighten us about today's topic, we have with us a very special guest, Mr. Arijit Prasad, Senior Advocate practicing before the Honorable Supreme Court of India. I would like to request Mr. Vikas Gupta to present a brief introduction about Mr. Prasad. Over to you, Mr. Vikas Gupta.
Thank you, Abhishek. Hello, sir. Arjit Prasad,
Hello.
sir, is a senior advocate designated by the Supreme Court of India. Sir holds a LL.B degree from the London School of Economics and is a qualified solicitor of the Supreme Court of England and Wales. Arjit, sir, is a practicing in the Supreme Court in the field of direct and indirect tax law for the last 21 years and has more than 350 reported cases in the Supreme Court under his name. Sir is a special counsel of the tax department in the Supreme Court and earlier had been the counsel of the income tax department in the Delhi High Court. Before going to sir, I would like to give mic to Abhishek again because he has an announcement before going to the sir. Over to Abhishek.
Before starting the session, I would like to thank all of the viewers for joining in, and I would like to inform that our viewers can now ask questions from the speaker directly by writing it in the comment section below throughout the session. And we'll be taking up those questions at the end of the very session, and we'll try to get as many answers as possible from Mr. Arijit sir. Now over to you, Arijit sir.
Thank you very much, Vikas and Abhishek. It gives me immense pleasure to be here today for this training program conducted by Law Curators. I was given the subject called arbitration, and everybody knows arbitration is something which goes hand in hand along with litigation, dispute resolution. And the very important topic which people are discussing nowadays is about the enforcement of arbitration awards. And the public policy is a defense taken by most of the people when an arbitration award is being enforced. So public policy, people know what public policy is, but in spite of that, public policy has not been defined. Therefore, public policy is found to be a very, what shall I say, easy ground to be taken by a party who has lost in arbitration before an arbitration could be enforced. Everybody knows that for the successful completion of an arbitration is finally the enforcement of the award. Unless an award can be enforced, the award is of no value even if the award is in your favor. Now, arbitration was designed to subserve the cause of facilitating international trade and promotion thereof by providing for speedy settlement of disputes arising in such trade. Recognition and enforcement of an international arbitration award is the culmination and the resultant end of an arbitration proceeding. The New York Convention has been guiding factor in international arbitration proceedings. India is a signatory of the New York Convention. The New York Convention provides for a very narrow spectrum under which an arbitration award's recognition and enforcement could be challenged. Consequently, the grounds of challenge of recognition and enforcement of an international arbitration award in India is also in a very narrow compass. However, one of the most commonly invoked grounds for challenging the recognition and enforcement of an international award globally is the ground that the arbitration award violates the public policy of a country where the award is sought to be enforced. When an arbitration award is rendered internationally, the arbitration award could be enforced either in the country where the parties stay or wherever the parties have their assets, so that the arbitration award could be enforced and the money is recovered. Thus, in other words, in the field of private international law, courts refuse to apply a rule of foreign law or recognize a foreign judgment or a foreign arbitral award if it's found that the same is contrary to the public policy of the country where it is sought to be enforced. Therefore, public policy comes into play when a party wants to get his arbitration award enforced. Now, what is public policy? What is meant by public policy whose violation renders an international arbitration award inoperative? It has been extensively debated not only in India but also in the United States, England, France, Singapore, Malaysia, Hong Kong, and all other major jurisdictions wherever parties have sought to enforce the international arbitrations. Now, this debate is not new. This debate has been going on for a very long time. In 1853, the House of Lords in England, in the case of Egerton versus Brownlow, identified public policy as that principle of law which holds that no subject can be lawfully do what has a tendency to be injurious to the public good or the public at large of a particular country. In Deutsch versus Ras Al Khaimah National Oil Company, the Court of Appeal, again in England, held that the consideration of public policy can never be exhaustively defined, but they should be approached with extreme caution. Referring to Richardson versus Mellish, the Court of Appeal further held that to uphold the challenge on the ground of public policy, it has to be demonstrated that there is some element of illegality or that the enforcement of the award would be clearly injurious to the public good or possibly that enforcement would be wholly offensive to the ordinary, reasonable, and fully informed member of the public on whose behalf the powers of the states are exercised. Arbitration in England and the English court does not enforce or recognize a right conferred or a duty imposed by a foreign award where, if on the facts of a particular case, enforcement, or as the case may be, recognition would be contrary to the fundamental policy of English law. The English courts have refused to enforce an award when, according to the English courts, the same would be contrary to interests of England or contrary to justice or morality. So far as the English courts are concerned, public policy was a very wide concept. Not only did they refuse to enforce an arbitration award when it seemed to be injurious to public or the public morality, but also if it in any manner seemed to affect the English country or the England's interests in any manner as well. The approach of the American courts to the doctrine of public policy in enforcement of foreign arbitral award is reflected in the decision of Parsons and Whitmore, Overseas Company Inc., and Society Generale de l'Industrie, where it was held the general pro-enforcement bias of the New York Convention explained the supersession of the Geneva Convention, and it points towards a narrow reading of the public policy defense. Now, international arbitration was, before the New York Convention came into place, was the Geneva Convention. That was the convention which all the various countries signed and followed the Geneva Convention. Geneva Convention has been followed by the New York Convention. The New York Convention gives very narrow grounds under which arbitration could be resisted. Therefore, it's the view of many commentators that after the commencement of the New York Convention, arbitration enforcement has become easy because the grounds on which arbitration could be resisted has become very narrow. It has become very narrow. Therefore, Parsons and Whitmore Overseas Company Limited, the American doctrine of public policy and enforcement of foreign arbitration awards was laid out, where it was specifically held that the general pro-enforcement bias of the New York Convention explained the supersession of the Geneva Convention, and it points towards a narrow reading of the public policy defense. Therefore, it understood and explained that the Geneva Convention was more wider in nature. Therefore, people had more grounds to resist international arbitration. But when the New York Convention came into being, the grounds for resisting an arbitration became very narrow. And when a country becomes a signatory to the New York Convention, what happens is then when somebody from abroad wants to enforce an international arbitration award, the grounds available to the people there are very narrow in nature. It was further held that an expensive construction of this defense would vitiate the convention's basic effort to remove pre-existing enforcement to obstacles to enforcement. Enforcement of foreign arbitral award may be denied on the basis of public policy only where enforcement would violate the forum state's most basic notions of morality and justice. This basically meant that a country could have various notions of public policy and public morality. So, an arbitral award can be resisted or its enforcement could be stopped only when the court felt that the grounds of the basic morality of a country is being violated. Similar has been the case in Lauch versus Standard Oil Company. There, again, it's an American case. The courts have held that the courts are not free to refuse to enforce a foreign enforcement of a foreign arbitration award at the pleasure of the judges to suit the individual notion of expediency or fairness. The courts cannot close the doors unless enforcement would violate some fundamental principle of justice, some prevalent conception of good moral, some deep rooted tradition of the Commonwealth. Therefore, this judgment specifically explained that what is public policy would not depend upon the person who is judging that particular case. The personal biases of the judges, the personal understanding what a public policy could be, would not matter. What would matter would only be some conception of good morals, some deep rooted tradition of the commonwealth of that particular country, if it is seen that enforcement of an award would violate those particular notions, then only public policy would come into being. Now we move to France. Again, France has a very old arbitration system. The France arbitration has been going on for a very long time. The International Court of Arbitration is also based in Paris. The lawyers all around the world look up to France as well to see how the French courts are deciding arbitration matters. So France is an important jurisdiction where arbitration law has developed over the years. In France, a distinction is made between international public policy, which is also called Ordre Public International, and the national public policy, that is the public policy of this French nation. Under the new French Code of Civil Procedure, an international arbitral award can be set aside if the recognition or execution is contrary to international public policy. In doing so, it recognizes the existence of two levels of public policy: the national level, which may be concerned with the purely domestic considerations, and the international level, which is less restrictive in its approach. Therefore, when somebody files a case for enforcement of an international arbitration award, that particular award can be resisted in France only if the public policy is of a nature which is deemed to be violating the public policy of the international level or the world at large. Any public policy which pertains to specifically the French nation, that would not come in the way of enforcement of a international award, because international award, one has to look at the international morality or the public policy at large. Therefore, in France, what we have is two types of public policy, one for international awards, one for national awards. Now, according to Redfern and Hunter is one of the most renowned authors. So far arbitration law is concerned, they are English authors. And this is a book which is referred to by practitioners as well as students when they look up arbitration law or a commentary. Even while we were studying in England, we had arbitration as a subject. And for us, Redfern and Hunter was one of the basic books that we were prescribed, which we had to go through. Now, according to Redfern and Hunter, if a workable definition of international public policy could be found, it would be an effective way of preventing an award in an international arbitration from being set aside for purely domestic policy consideration. But in the absence of such a definition, there are bound to be practices which some states will regard as contrary to international public interests and other states will not. Therefore, what basically Redfern and Hunter tries to tell us is that when an international arbitration award is sought to be enforced and it is being resisted on the ground of violating a public policy, one has to look at the international public morality as a whole. One need not or one should not look into the public policy of a particular country. Therefore, in case a public policy of the world as people understand is violated, and only in such cases can international arbitration awards enforcement could be resisted. But if a particular public policy which is local to a particular country, if it is being violated, then the international awards enforcement cannot be and should not be uh, allowed to be resisted in any manner. Now, even in India, what is meant by public policy has not been defined in the Indian Arbitration Act. And therefore, what is public policy has been an issue of many debates in many seminars and conferences and yet to be conclusively settled by judgments of courts. Public policy has not been defined even in the Arbitration Act in 1940. It has not been defined in the Arbitration Act of 1996. And even the latest amendments, public policy has not been defined. So what is a public policy whose violation renders a international award being resisted and can't be enforced in India is something which again has developed because of the various judgments which a court has come into. There is nothing in the statute to say what is a public policy whose violation will not allow an international arbitration to be enforced in India. Now, in one of the earliest cases on arbitration, the Supreme Court in Central Inland Water Transport Corporation versus Brojonath Ganguly has held that public policy is a notion. It's something which is not capable of being defined in a very precise manner because public policy for various people, the basic morality changes from time to time. It changes from person's perspective. Therefore, it cannot be straitjacketed and put into a particular straitjacket formula. This is what the public policy of India is, and if this gets violated, the international award can't be enforced. Now, Central Inland Water Transport Corporation versus Brojonath Ganguly is one of the earliest judgment of the Supreme Court on public policy. The Supreme Court has said public policy is not capable of being defined in a precise manner. However, the court explained that public policy connotes some matter which concerns the public good and public interest. Therefore, what is public policy? The Supreme Court says this is something which concerns the public good and the public interest. Therefore, any international arbitration award, if it is sought to be enforced and if it is resisted on the ground of public policy, it should mean that it affects the morality of the Indian people or the morality of public good. If such an award is enforced, it would have an adverse effect on it, then it would amount to violating of the public policy of the country and such an award shall not be allowed to be enforced. Now, thereafter, we come to Renu Sagar Power Company Limited versus General Electric Company. This Renu Sagar Company versus General Electric Company is a landmark decision so far as enforcement of arbitration awards in India is concerned. We had this judgment been rendered by Supreme Court. Big lawyers who have are known to be stalwarts in the legal fraternity had appeared and argued this matter. Now in Renu Sagar Power Company versus General Electric Power Company, a landmark decision of the Supreme Court, the court extensively discussed the concept of public policy. It construing the expression public policy in the context of a foreign award, the court held that an award contrary to the fundamental policy of Indian law, the interest of India and justice or morality would be set aside on the ground it would be contrary to public policy of India. This is a judgment where the Supreme Court tried to bring about certain kind of parameters for people to understand what public policy would mean. Even though in Brojonath Ganguly, the Supreme Court said it cannot be defined in a precise manner, in Renu Sagar, it tried to give some kind of a parameter whose violation would render an enforcement and arbitration award a nullity. Specifically, in this matter, the Supreme Court gave the parameters. Now, what are those parameters? The Supreme Court said in understanding what public policy would mean in the context of enforcement of a foreign award, the court held that an award is contrary to the fundamental policy of Indian law, the interest of India, and the justice or morality. In case enforcement of an international arbitration award is allowed to be enforced and it violates the fundamental policy of India, violates the interest of India, or violates the justice or morality of what India considers it to be, then on such a ground, the enforcement of an international award would be contrary to public policy in India. Now, Renu Sagar Power Company has been followed by various other judgments of the Supreme Court. Now, in Sangyong Engineering and Construction Company Limited versus National Highway Authority of India, the Supreme Court, while interpreting public policy, held that the public policy of India whether contained in Section 34 of the Arbitration Act or the Section 48 of the Foreign Award Enforcement Act, would now mean the same. Both the sections are parameteria, and fundamental policy of Indian law, as a fundamental policy of Indian law, would be relegated to the Renusagar understanding of this expression. In spite of the Renusagar's judgment, there have been various judgments in courts, and in various judgments, people have argued what public policy of India would be, in spite of the court laying down it to be the fundamental uh, policy of Indian law, interest of India, and justice of morality, to expand it at times according to what their case is. Some people read it in an expensive manner, some people read it in a narrow manner. So, in Sangyong Engineering and Construction Company versus National Highway of India, the Renusagar Power Company versus General Electric Company judgment has been again reiterated to mean that fundamental policy of Indian law, that is a fundamental policy of Indian law, would be relegated to what the understanding of public policy as was enunciated in Renusagar. Therefore, what is a fundamental policy? What is the fundamental public policy whose violation international arbitration will not be allowed to be enforced in India would mean what has been held in Renusagar. Therefore, in proceedings for an enforcement of a foreign award under the Foreign Awards Act 1961, the scope of inquiry before the court in which an award is sought to be enforced is limited to grounds mentioned in Section 7 of the Act and does not enable a party to the said proceedings to impeach the award on merits. This would imply that the defense of public policy, which is permissible under Section 7(1)(b)(2), would be construed narrowly. Similar was the view of the court in many other judgments that follow Sanyong, including in Vijay Karya versus Prismian Kavi. Now, what has happened is this. Various judgments, various different issues come up, there are various different facts, and lawyers on either side try to say that this violates in public policy, that doesn't violate public policy. Therefore, in all these cases, line of cases, what the judges have held, what the courts have held is that the public policy as was enunciated in Renusagar Company, as was given therein, would mean the public policy of India. However, the Supreme Court in Alimenta SA, which is a recent judgment, departed from the aforementioned line of judgments that follow Renusagar, which construed the defense of public policy narrowly and allowed the challenge of enforcement of international arbitration on the ground of public policy, construing it widely. In this case, the court allowed the challenge on the ground that the award not only did not deal with the restrictions imposed by the government as to export of the commodity, but also because the appellant NAFED was a canalizing agent of the government and could not have exported the commodity contracted for the season of 1979-80 in the year 1980-81 without approval of the government. The court also took notice of the fact that NAFED could not execute the contract because of the restricted export policy and quota ceiling under the export control order. Therefore, the court was of the view that export without permission would have violated the Indian law, thus enforcement of such an award would be against the fundamental policy of India. Alimenta versus NAFED is a very recent judgment of the Supreme Court. In this case, what happened was NAFED was a canalizing agent, and NAFED was not able to make the exports which was contracted to be exported in 79-80 in the next year. This mainly happened because the Indian export laws changed and the government did not grant NAFED the power to export. In such a scenario, in spite of that, the arbitration award, without taking into consideration of the fact that the Indian government did not allow NAFED to export, gave an award against NAFED. So when this particular award was sought to be enforced in India, the judges of the Indian Supreme Court looked into the fact that the execution of the contract could not take place because the law in India had changed. And therefore, such a arbitration award against the Indian company who could not enforce the contract because of the fact of the government change in law, such if an arbitration award is enforced, it would be violative of the Indian public policy. Therefore, it can be seen that public policy, by its very nature, of a very dynamic character, And still, there is no straitjacket formula to define public policy, and any classification may crystallize public policy only at a certain point of time, and it would vary according to the challenging times and changing morality of the public of a country. Now, when this judgment of Alimenta and Nefed was rendered, there were a lot of commentators and opinion makers who write about arbitration law. They said that this particular judgment is not in line with Renu Sagar Power Company, but it is a little divergent in nature because it looks into the public policy in a more wide nature. If you recall, I had just mentioned about Redfern and Hunter and also the French public policy, where the idea is that you look into whether it violates the public policy of the world as a whole and do not look into your domestic public policy, how it is going to be. Alimenta is a little divergent in because of the fact that it looks into the very fact that Indian law was being violated, and if Indian law is violated, it would amount to violation of the Indian public policy. Therefore, what is public policy is still very fluid. There is no straightjacket formula in which you could say that this would violate public policy or that would violate public policy. However, the Renu Sagar's judgment, which has been followed by various judgments in various cases, still holds the field, and what has been enumerated to be public policy in Renu Sagar still holds. Therefore, violation of Indian law, the interest of India or justice or morality as the Indian people would seem to hold, if any arbitration award violates those particular notions, then an arbitration award cannot be enforced in India. Therefore, what I say is that public policy has by its very nature a dynamic character. Still, there is no straitjacket formula to define public policy, and any classification of public policy would be only at a certain point of time, and it vary according to the changing times and changing morality of the public of a country. What was held to be public policy, that is why Brojanath Ganguly's judgment said there is no precise manner in which a public policy could be straitjacketed or parameters laid down. However, there is no doubt that the finality of award is of a paramount importance in international commercial arbitration. There is a recognized international policy in favor of enforcing awards, as it ensures certain degree of certainty and predictability in the international arbitration process, as it provides stability to international trade. Now, if there are various different notions of public policy in different countries, international arbitration as a concept would be in jeopardy, because ultimately international arbitrations have been brought in to adjudicate dispute between parties of various nations. Therefore, it is important that whatever award an international arbitration tribunal comes into renders it, it should be final and it should be able to be enforceable. Otherwise, all the time and money spent in fighting or representing and adjudicating in international arbitration would be all futile. In spite of that, it would be clearly wrong to expect all awards to be enforced just because it has been rendered by international tribunal, even if it violates or bypasses the fundamental and mandatory laws of the enforcing state or jurisdiction. Further, to expect court enforcement of international awards without any encroachment of domestic peculiarities and moralities would be a logical impossibility, like both having and eating the proverbial cake. Therefore, we would see and we have seen a balance is always being maintained. What amounts to fundamental policy of India, what amounts to the fundamental justice and morality of India, and what are the notions whose violation would render an international arbitration not being enforceable in the country. So I hope the topic is very small. What is public policy? I've tried to explain what a public policy is, what public policy has been understood by the English courts, what public policy has been understood by the courts in the US, what a public policy has been understood by the courts in France, and what our Indian law means, what it has been explained public policy to be. Therefore, public policy is and still remains as a ground or a defense for enforcement of International Arbitration Award. Arbitration, the Neo Convention governs it. India is a signatory to the Neo Convention. Neo Convention lays down a very narrow compass within which international arbitration could be challenged. Therefore, according to me, even the public policy in India should be construed in a very narrow manner. I hope my talk on public policy helps my friends here to understand how public policy is construed in India. Thank you very much. Over to you, Abhishek. Thank you.
Thanks a lot, sir. Thanks for giving great insights to the topic. Now let us proceed towards the Q&A session. I would like Mr. Vikas Gupta to ask the questions. Over to you, Mr. Vikas.
Thank you, Arjit sir. It was a very
Thank you.
insightful session for all of us. Sir, our viewers would like to know whether the arbitration is a good area of practice in India.
Absolutely. I mean, arbitration and your normal litigation in court goes hand in hand. Arbitration is mostly is a private adjudication of a dispute. Arbitration came up mainly because of the fact that commercial disputes in court took a huge time and money. Therefore, arbitration was brought in as a concept to have a speedy redressal. And arbitration over the years has grown tremendously, and litigators who appear and argue matters in court also do a lot of arbitration matters, and there are a lot of lawyers today who do only arbitration matters and don't even go to court. Therefore, I feel arbitration is a very good area of practice for youngsters who want to join law and who are also in the profession so far of
Thank you,
now.
sir. Following on my question, do you think the NAFID case will have any adverse effect on the arbitration?
I just explained Alimenta versus NAFID. Even though the Alimenta versus NAFID case goes and diverges a little bit from what the Renu Sagar and the line of judgments have been rendering in judgment, or what they have explained public policy to be, public policy ultimately is what is fundamental to the Indian understanding of morality. Even though in France and Redford and Hunter have said that the Neo Convention construes the defense against an international arbitration tribunal to be very narrow, uh, I still feel this is a judgment which has followed what Renu Sagar and the other judgments have construed public policy to be in India. Therefore, even though some commentators are saying that it is digressing from the what the line of thinking of the earlier judges and judgments are, I don't see it to be too much of a digression. I don't think it would have any adverse effect.
Thank you, Arjit sir. It would have been a very insightful session for all the viewers. Thank you, Abhishek.
Thank you very much. Thank you, Vikas. Thank you, Abhishek. Thanks very much for your platform, and thanks very much giving me an opportunity to tell all my young friends what public policy is, what public policy amounts to, how it is a defense in enforcement of International Arbitration Award. Thank you very much. Thank you.
Thank you very much.
Okay.
Thanks a
Thank
lot,
you.
sir. And also, I would like to
Thank you.
thank all the live audience that joined in for the session. We are deeply thankful to Mr. Arijit Prasad, sir, for elucidating on today's topic and providing such great, insightful views. Thanks a lot, sir, and thanks
Thank you
everyone
very
for
much.
watching.
Thank you. Take care. Thank you. Bye.
Thank